It's 7 p.m. I'd like to call the meeting to order. Today is February 22nd, 2024, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We'd like to take a moment by acknowledging that the land in which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tangva and Gabrielino Quiche people. Commissioner Bass, would you lead us in the Pledge of Allegiance?
Please rise and repeat with me.
Thank you, Commissioner Bass. I hope everyone's doing great this evening. Happy Black History Month. I hope you've had an opportunity to, go to an event or do something that honors the legacy and contribution of Black Americans. And if you haven't, you still have time. Madam Secretary, may we have the roll call, please?
Yes, Commissioner Bass.
Present.
Commissioner Kruppies.
Present.
Commissioner Martz.
Present.
Commissioner Rory.
Present.
Commissioner Topshin.
Here.
Vice Chair Moore. Here. And Chair Wright.
Present. We have a quorum. If everyone's had a chance to review tonight's agenda, I'll entertain a motion.
I'll make that motion.
Okay, thank you. Is there a second?
A second.
We have a motion and a second to approve the agenda. Madam Secretary, roll call, please.
Commissioner Bass.
Aye.
Commissioner Kruppies.
Aye.
Commissioner Martz.
Aye.
Commissioner Rory.
Aye.
Commissioner Topshin.
Aye.
Vice Chair Moore.
Aye.
Chair Wright.
Aye. Motion passes. All right, we have the minutes from the July 11th, 2024 Rent Stabilization Commission meeting and the July 25th, 2024 Rent Stabilization meeting. Do we have to take them, can we take them aggregately or do we need to do them as separate motions for approval?
You mentioned July and it's January. Chair Wright. Just making
January.
that correction.
Okay, thank you. Can we do them as an aggregate motion?
You could do it as a separate motion, that's fine.
Okay.
I'll move both of them.
Okay, wonderful. And thank you for correcting the date. So we have a motion for approval of those minutes.
Does it make any difference that I wasn't here on the 25th, so would need to abstain from that one?
Yeah, on that one, I think three of us were absent.
I think if you just note for the record which one that you're abstaining from, you could still do it collectively as a motion.
Thank you.
Okay. I already have a motion. Is there a second?
I second.
I already have a motion and a second to approve the minutes from January 11, 2024 and January 25, 2024. Madam Secretary, roll call, please.
Yes, Commissioner Bass.
Yes on the 11th, abstain on the 25th.
Okay, noted. Commissioner Kruppies.
Aye.
Commissioner Martz.
Aye on the 11th, abstain on the 25th.
Noted. Commissioner Rory.
Aye.
Commissioner Topshin.
Aye.
Vice Chair Moore.
Aye.
And Chair Wright.
Aye. Motion passes. Item number 6 on the agenda is public comment. Madam Secretary, do we have any public commenters?
No public comments.
Okay. Well, public, if you're watching from home, you still have time to get down if you want to make a public comment. Item number 7 is the manager's report. Our acting rent stabilization manager, Gloria Vilas, will review the look-ahead calendar for us.
Good evening, Chair Wright and Commissioners. I'm very, very happy to be here since we missed our last meeting. They withdrew those appeals, so we weren't able to meet, and I really look forward to seeing you guys. So I was a little sad, but I'm glad we're here today. We do have on the look ahead calendar, tonight will be an appeal for D case 4794. At our March 14th meeting, we will have 2 appeals and a presentation on the Justice for Renters Act. I believe Hernan Molina will be also here to give us some more information about the act in case questions come up. And then on the March 28th meeting, we will be having another appeal. That's it.
Wonderful. And we had an amazing time last meeting. With playing a game, Cahoots, et cetera. So I believe we did attach those, the questions, et cetera. So if the public wants to see what questions we went over and the answers, or the commissioners that weren't able to make it, you do have that opportunity. They were really good questions and provided some really great insight. Item number 8 on the agenda is, go ahead.
One question. I think it was between now and the last meeting that we received our for those of us in the rent stabilized units anyway, we received our newsletter. And I think, is there any way to, the city doesn't have any idea as to who requests from their landlords in that process the interest payments, correct? That's really just between the landlord and tenant conversation with the use of that form.
Yeah, I believe the actual form has an option for the landlord to send it to the tenant and say, one, here's your check, or two, you could deduct it from your upcoming rent. Or the tenant can also use the same letter and say, hey, since you didn't pay me by the 31st of January, I'm deducting it from my rent. So the form is available at City Hall. I believe we would normally send it with the newsletter. I don't think we included it this time.
Yeah, it was.
Did we?
Yeah. At least it
So
was in
both
mine.
tenant and the landlord can use it.
Okay.
Yeah.
So my question is, so on the form, it's a little bit vague or it's a little bit confusing in that it says that you have until, it makes it sound like you only have until the end of February to resolve this, but really there is no deadline, right?
No, if it's within that year that it's applicable, then they can
Okay.
do that.
And then I just happened to be at City Hall today to pay a traffic ticket, or not a traffic ticket, but a parking ticket. And I happened to be there, and I was looking. Is it possible to put those forms available there on the first floor with the other rent stabilization forms?
The security deposit interest? Yes.
Yeah,
Absolutely.
I just don't think many people know about it in the city because of so many years of it being
Sure.
zero. Thank you.
Are there any more questions for staff? Alrighty, moving on to item number 8 on the, which is the appeal. The appeal is set forth as D4794. Excuse me. Do we have a representative for the tenant and the landlord?
Neither the tenant or the landlord have checked in, but they both confirmed attendance.
And they both confirmed in person or via Zoom?
In person.
In person attendance. All right. Do we table and just go through the other items and then come back?
So there's a couple things. One is there's no requirement that the parties be present, so the commission is free to go forward with it. The commission could continue the item to another hearing if they felt that they actually needed the parties to resolve this appeal. Or if you wanted to go through the rest of the agenda and move this to the very end, then somebody could just make a motion to move the appeal to the end of the meeting and then take all the other items.
Okay, got it. There's not a not a ton. I was looking, not a ton unless there are a bunch of items from commissioners. Someone just walked in, so we'll see what happens there. But as we're waiting for that to happen, I think we can start thinking about whether we want to proceed without the parties or.
I don't mind proceeding without the parties, but I would move that we move our one item or our commission comments forward versus by an extra couple minutes. I don't know.
Got it. Okay.
The landlord is present.
Okay, the landlord's present. The tenant, the appellant still hasn't appeared? No. Okay. Were there any other suggestions or ideas of how we want to proceed?
Since we have the landlord present, so we can just move on.
Okay. All right, I agree with that. So we do have the landlord present, so we can proceed with testimony from the landlord. But first, we will hear the staff report from our legal counsel, Jonathan Natalizio.
Thanks, Chair and Vice Chair and Commission. Good evening to the public. My name is John Natalizio. I'm the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. And this appeal hearing tonight results from a hearing examiner's decision denying a rent reduction application for issues relating to restoring use of a in-unit washer and in-unit dryer. The decision's basis for denying the rent decrease is that the washer and dryer were not a housing service which was provided by the landlord, and that tenant had failed to meet her burden of proving that by a preponderance of the evidence. And tenant did file the appeal, which claims that the decision is clearly in error and is not reasonably supported by the findings made or evidence in the record. Staff finds that there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value, and staff believes that a reasonable fact finder could come to the same conclusion, even if there's contrary evidence in that record. Other than tenant's testimony, staff found that there was nothing in the record to support the in-unit washer and dryer were a landlord-provided housing service, and that the hearing examiner considered this testimony already and deemed it was insufficient to meet her burden in light of other facts and evidence. And so staff finds that there isn't a basis to disturb this determination. Staff recommends adopting Resolution RSC 24-644. You as the commission have the power to affirm, reverse, modify, or remand the appealed decision to the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there is substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there is also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence, and as relates to questions of law, the commission applies an independent standard of review. Thank you.
Are there any questions for staff? Yep, Commissioner Topchin.
Thank you, Chair. Good evening, Mr. Natalizio. There is a registration form in our packet dated August 10, I believe it's 2025, that the laundry facilities box is checked. Although this is from a later time, 2025, but I wonder if the hearing examiner considered this registration form, did give any weight to this form, and why this form checks the laundry facilities. Do you know anything about it? Or we should ask the landlord.
Are you looking at, in terms of our packet, what Bates stamp number is
I think the
this?
page 54 of our packet.
Give me a second. I'm on page 58 of at least the PDF. I don't see a Bates stamp, sorry. But it's right after the
It's right
re-registration form.
On the packet we have page 53 is the document titled Unit/Building Services Report, and the next page, I assume that would be number 54. It's the city's rent stabilization registration form.
Oh, I see what you're saying, sorry.
Yeah.
So just as a point of clarification, this is the initial registration form that would have been submitted back in 1985 when landlords were required to register the property. And what we look at as laundry facilities is an actual facility, meaning there's a laundry room that has a washer and a dryer that the entire, all the tenants have access to. That's what we mean by laundry facilities. If it was in any unit, dryer and washer, it would indicate that. But for the purposes of this form, the laundry facilities means there was a room that was considered a laundry that all the tenants had access to.
So meaning the laundry facilities references to the common area laundry facilities.
That's correct.
And is there common area laundry facilities in the building?
Commissioner, I'm not sure what the
can
common
ask the
area,
landlord.
but I will say, if you go to the page below that, it's the second page of the registration form, and there's specifically a washer in unit, dryer in unit check that if there was going to be, that's what would be selected.
I see.
To
That's
help
what-
clarify.
Okay, that's the page the examiner looked into. But I'd like the landlord to respond to that question about the registration form. Thank you, sir. Nothing further.
Any other questions from commissioners? I have a, go ahead. Vice Chair Moore.
Sorry, I need to get back to my page. Just why was there so much time in between when the appeal was filed on September 28th, 2023 and the hearing? Is there a reason for that?
In terms of this hearing, or in
Yeah.
terms of the actual hearing?
This hearing? Because
It's
usually
just-
I feel like closer.
It's just an issue of when we're able to get to it. When there's
Okay.
kind of more complicated cases, it takes longer, and so it's just, that's kind of the only factor.
Okay, thank you.
I had a question about the Bates number is 51. It's marked as Exhibit 6. It's titled Estoppel Certificate. It's dated December 1, 2015. So I looked up the code section at the bottom, RSO 17.52.010, subpart 6, and it looks like this form is generally submitted when the landlord doesn't want to renew the tenant's lease and there's an actual, like a reason why. And so sort of read, why the tenant would submit this form. So it looks signed, dated by the tenant December 1, 2015. And then for number 6, do you have it before I continue?
I have it open.
Okay, perfect. And so for item number 6, it says the original lease has not been modified except as follows. And it says increase 3% every year except one since 1998. Security deposit to, I think it says remove washing machine. Do we have any other context regarding this exhibit?
So from my understanding is estoppel certificates are usually utilized when a new property owner is going to purchase the building and they have the tenants fill out these estoppel certificates so they can assess risk and be able to determine profitability. It's a tool for the prospective property owner in evaluating. That's my experience with estoppel certificates in this context. But I do see that line. And other than that, I'm not sure.
Did reading this sentence like sort of weigh at all on the staff report sort of regarding, who knew what when regarding, that the washing machine was in the apartment, and sort of when it was placed? I guess did this affect at all the staff report regarding the washing machine?
So I did see this, and I believe that the hearing examiner did as well. In my staff report, I referenced that, in reviewing it, I still think that the evidence in the record could reasonably support what the hearing examiner came to. I think this is an example of kind of when I read my staff report and what I put, when I give my oral report and what I put in the staff report, which is there is evidence, in records which can support different outcomes, but that isn't determinative of whether or not substantial evidence could or could not be met. But to answer your question directly, yes. I mean, the fact that this is in an estoppel certificate from 2015 can lend it to what you're saying, but at least this didn't change my opinion.
Okay, thank you.
I also have another comment, just so that you guys know, just as John Natalizio mentioned, that this is used when there's a prospective buyer. We see it more often when the prospective buyer doesn't have a lease. So this is what they now base new information. So if the prospective buyer sees that there's no lease agreements available for them on a particular unit, then they would request this estoppel certificate so that they know what was being provided at the time of the tenancy when they took over the property. And this is not filled out by the property owner, this is filled out by the tenant and signed by the tenant. So it's what the tenant is reporting. It's not something that the previous landlord filled out for them or anything like that.
Got it, thank you. Are there any more questions for staff?
No questions, just a comment, Chair. The tenant is now present.
Alrighty, good evening, welcome. We are just now getting to the hearing part of the appeal. And so the rules for the appellant, who is the landlord this evening, and for the respondent, who's going to be the, did I say landlord? I'm sorry. The appellant is the tenant this evening, and the respondent being the landlord. So the tenant will speak first. You will have 5 minutes. You can divide your time into 2 segments, so you can present your case, and then you can also do a rebuttal. You can take it all at once. You can divide it how you want to. Just let me know how you want to divide your time, if at all, when you come to the podium. The landlord will have 5 minutes to speak. It will be one segment. It's not divisible. When it's your turn to speak, please state your name and your city of residence for the record, and then proceed with your comments. And just some pointers, please stay on topic. So the only issues that we can make decisions on this evening are the issues that are on appeal before us. And so please make sure that your presentation of your case and your rebuttal are on the points that we can actually make a decision on this evening. And so for now, I will ask the tenant to please come to the podium. You can adjust the mic, so make sure we can hear you, and then state your name and city of residence, and then let me know how you want to divide your time.
Thank you. Hello, I'm Christine Prejean. I live at 8359 Rosewood in West Hollywood.
Okay, and how would you like to divide your time? You have 5 minutes. You can.
Oh, yeah, maybe 3 minutes for the presentation and then a little time, 2 minutes after.
Okay, perfect. 3 and 2. Thank you. And you can begin when you're ready.
Okay. I don't know what order I should mention all this in. There was a private meeting between the owners and the hearing examiner, to which I wasn't, not that I wasn't invited, I was particularly excluded. Before the meeting, I got there early and I was waiting in the lobby, and someone came out and said, "Time for the meeting." And I walked up there, and the landlord's representatives went up there, and then they got there faster. I'm a little slow. And then they said, "No, you're not to go in yet," which I thought was a little odd at the time, but I've since spoken to someone that was pretty much inappropriate. And after the meeting, they stayed, and I wasn't invited. Okay, that was one point. The other point that was mentioned in the hearing examiner comment, there was never any determination that my washer and dryer connection is not within code, because I don't think anybody ever inspected it, and I certainly wasn't informed of it. And then, so I would wonder what it would take to bring the hookups, the connections, up to code, and can't be that costly. I don't particularly need the rent reduction. I just want my washer and dryer back. The other point is that the mold and mildew is still growing in my neighbor's apartment and in the hallway between mine and hers. And my washer has been disconnected since February, actually 22nd of 2000, last year, 23. I'm sorry, I'm a little out of breath. And then there were a number of errors in the hearing examiner's report, and I pretty much get it that by the legal definition, my washer and dryer was not housing services. The landlord, the previous landlord, when I first signed, shortly after I moved in, which was 24 years before all this started, the previous landlord at that time put in the connections, and I got the washer and dryer. I've already got the washer and dryer. All I need are to have it reconnected. And the hearing examiner.
Ma'am, That's your 3 minutes. You can continue going. We just wanted to check in and let you know that you're at 3 minutes now.
I'm sorry, oh, it's 5?
You're at 3. You still have 2,
Okay.
but if you want to save it, you can, or you can continue, and then
Well, I
whatever's
just
left
have
over.
one more sentence.
Okay, go for it.
The hearing examiner deduced that the landlord would not have installed it that way, which he did, and that there would be no reason to do that. And so he's like interpreting what my landlord thought 20 years ago. And, but he did say he just wanted to make it easy to remove the washer and dryer connections for the next tenant. And that's the reason that I would like the washer and dryer to be reconnected.
Okay. Thank you. Just stay at the podium for a moment. The commissioners may have questions for you.
Oh,
Just curious as to, was there a reason you were unable to provide testimony provide evidence other than your own statements? Like at the hearing, did you consider talking to the landlord, the previous landlord?
yeah, because the previous landlord never wrote anything up about it. I didn't ask. I didn't think, he thought it was okay just to put in the hookups, and I didn't know that I was supposed to ask for things in writing, and that was a long time ago, and he was kind of elderly at the time, and I didn't call his family.
Okay, thank you.
For that reason. Any other questions?
Yeah, I do have a question. Were you responsible for all of the repairs and
Oh,
the
yeah.
maintenance and the upkeep?
I was, yeah. And as far as evidence that the washer and dryer was there, I have repair, or at least one repair bill, prior to the current landlords having purchased the property.
Got it. So did a landlord, I know you've gone through quite a few since you've been there, did a landlord ever make any maintenance or repairs or do sort of any upkeep on the washers and dryers since they've been in the apartment?
Did he make repairs? No.
Never, okay. And then is there a book there? One of the, okay. Can you assist her potentially in turning to page 51?
I'm sorry?
She's referencing this book.
Oh.
This is the evidence.
Yeah, I got it. Yeah, sure. Sure. I have a pen.
They're going to reference this, so they just want you to see it.
Oh.
Because of the
Oh.
information regarding.
Okay, got it.
So on page 51, you're looking at the estoppel certificate. At the bottom, looks like that's your signature dated December 1, 2015. Do you see that?
Yeah.
Okay.
Got it.
And then further up on the page, item number 6, it says the original lease has not been modified except as follows. Do you see that sentence?
Yep.
And then after that, it says security deposit to remove washing machine.
Yes.
Do you recall can you give us some context as to what that meant? Like, did you lose
Oh,
your
yeah,
security deposit? What was going on?
I'm sorry. Yes. I gave the previous landlord, or like 3 previous landlords ago, $100 so he could reconnect it the way it was, and he just kept it. I mean, it was a deposit, a security deposit for that purpose. It wasn't part of I don't think it was part of my original security deposit, which I think it was, I don't know, I can't remember. It might have been refunded. It was a long time ago.
Okay, got it. So it sounds like you're saying that you paid a deposit, and then did you pay an additional deposit to have the washing machine put in?
Yes,
Okay.
yes. I gave him an additional $100 because that's what he said it would cost to unhook the hookups and put it back for the shower that was there in the first place. The shower has a drain, so that's why we put the washer in that location. It has 2 bathrooms, and I didn't really need 2 bathrooms. I mean, it still has 2 bathrooms. It just only has, it's like a 1.5 bath.
Got it. And then just one more question for you. Can you turn to page 50?
Oh, 50-something a month for water use. He wanted me to pay a little extra every month because he said the washer would use extra water, which I did.
Got it. Page 57.
I don't know where, I remember doing it, but I don't know. Well, you guys have everything in good order. I see, re-registration, yeah.
Got it. So yeah, you're looking at the re-registration form that was filed with the city February 22, 2019. Do you recall what portions of this form you completed? It looks like your signature is about halfway down on the page.
Yep.
And so I'm wondering, did you fill out everything that's above that? Do you recall?
Yes,
Okay.
signature of new tenant, but I didn't do anything below that.
And is there a reason why you didn't check the in-unit washer and in-unit dryer on this form?
Oh, I guess, I don't know. I don't know, I didn't notice it. Is it on there?
Yes, ma'am. It's in one of the. It's in like the column above the P in your last name.
Oh, I didn't see it, I'm sorry.
Okay. Okay. No worries. I don't think there are any more questions. So what we'll have you do now, we'll have you. Oh, Vice Chair Moore does have a question.
Diane, if you don't mind helping her, on page 37, there's a receipt. It's just a little bit hard for me to read because it's very small, but I believe that it has your signature on it, and I believe that it's for service repairs.
Oh, yeah, that's the receipt that I
That's the
brought.
receipt. And so you paid for all of the repairs, just to be clear.
I'm sorry?
You paid for all of the repairs?
Yeah, evidently nothing broke in all that time except this one repair, I think it was to the dryer.
Okay. Thank you.
And that, on the opposite page, that's a picture of it, which is, it's not that attractive, but I didn't care. I needed a washing machine so I could, do my laundry.
Okay. Are there any additional questions? Okay. Seeing none from the commissioners, I'll have you take a seat. The landlord will then come. He'll have 5 minutes, and then you'll have the remaining time, which is.
Okay.
Sorry.
You'll have 1 minute and 20 seconds for your rebuttal
Yeah, if I have
after
a question or
after the landlord.
agreement or whatever.
Okay.
Thank
and
you.
I'll have the landlord or the representative come to the
I
podium.
should leave this here?
Yes, ma'am. Just state your name, city of residence, and then you can begin.
Good evening, Commissioners. My name is Nick Hilaris, and I live in West Hollywood. Thank you for your service to the city. I don't have much to add to this matter, just maybe want to just provide some context and then open it up for questions, if there are any. What happened in this case is we discovered that there was this laundry machine. There was both a washing machine and a dryer. And unfortunately, they were installed in such a manner that they were completely unsafe. And so it's sort of our fiduciary and legal responsibility to make sure that those kind of conditions don't continue. And so it's not like we came into this situation attempting to remove this laundry machine that apparently had been there for quite some time. And I'm sympathetic to the needs of Ms. Prejean to have an in-unit washer and dryer, and I would love to make it happen, but to do it to code in this environment is a significant expense. And so we don't have the resources in this building to do that. So unfortunately, that's how we ended up in this situation.
Okay, thank you. Commissioner Topchin?
Yes, hi. Good evening, sir. A quick one, actually. I had a question about the registration form, but I think it's clear to me. Is there laundry, common area laundry facilities in the building, on the premises?
Yes, there are.
There are. And how many machines? I just wonder.
I don't know for sure. I think
Okay.
it's just one wall. It's only an 8-unit building.
And that facility is accessible for everyone, right? Including the tenant of record, Ms. Perjan.
Yes. Yes.
All right. Okay. I just wanted to know that. Thank you.
Just a couple of questions. Can you remind me when you purchased the building?
I believe it was sort of late, either 2017 or 2018.
Okay, and had you seen the Gestapo, or you asked for the Gestapo form, right? I don't know if I'm saying it right, but, and did you review those when you received them, or did that raise an alarm to you at all when you saw that, or the Washington?
I don't honestly recall.
Okay.
Yeah, we do request the estaples when we purchase properties like this where it's difficult to get the leases, and we review them. But I don't remember even thinking about it. The first time I sort of personally had knowledge of this washer and dryer was just over a year ago when we were starting to get complaints about leaks and mold in an adjacent unit.
Mm-hmm.
And as our property management team went to look at it, they discovered that there was this improperly installed washing machine inside of a shower.
And approximately how, this sounds like that was pretty quickly. You investigated what the complaints were coming, what was causing the complaints, and then you figured out that it was potentially the washer and dryer, and then you notified the tenant. I mean, did it happen pretty quickly, or how much time did it?
I believe it happened very quickly. Okay. Because when our property manager went in to look, we discovered that the more alarming piece of it is that there was a dryer that was on the balcony. And so these dryers are connected to gas, and
no, I understand.
Gas can leak, and you can get serious consequences if it goes in the wrong direction or has a malfunction. And so that was the most alarming part. So we immediately notified the tenant to turn it off.
Okay.
Yeah.
Thank you.
Was there ever discussion of how to make the connection sort of safe as is? It seems that she's had it for 20 years, and so I'm wondering if, I assume nothing's happened in this time. I know it's not on the record, but I'm just curious if there was sort of any discussions about sort of making it usable or sort of meeting whatever requirements the repair folks sort of told you beyond sort of rebuilding an entire laundry facility in their apartment.
Yeah, we even had a contractor come look and bid it, and I don't remember the exact number, but the bid we got was like $12,000 or $15,000 to get it done. I'm actually open to it. I would still do it if we could get it done for a reasonable price. I don't know how you would, just based on the way the unit's set up, but I'm open to that. I don't feel like it should be our responsibility just because we didn't, we don't provide laundry services for everybody else, but I'm completely willing to allow that to happen if it's done by a licensed contractor and it's done per the city codes.
Got it. And it's your understanding that in the current state it violates some health codes or some city codes?
Yes.
Okay. Have you shared that with the tenant by any chance?
I think in the original correspondence that we had with her, we did, but I can't really completely confirm that right now.
Okay. And then has the mold issue been resolved, or is it mold still appearing in the adjacent apartment?
As far as I knew, up until just a few minutes ago when Ms. Prejean was speaking, I thought it was resolved. I hadn't heard anything from the neighboring tenant who brought it up originally. So we were under the impression that it was solved, but it sounds like it may not be, so we'll have to look into that.
Okay, got it. And there's a book in front of you. Can you turn to page 47? It'll be a small number on the bottom of the page. It's one of the Bates numbers.
Yep.
So is this an invoice that you submitted to the hearing officer?
Yes.
And this is regarding the adjacent unit number 6?
Yes.
Okay, so in the description, the last line, it says apartment maintenance number 6, patch and paint where wall heater was removed. Did anyone ever, I guess let me start over. So there was a wall heater in that unit. Was it sort of in the same area that the mold issue arose, or was it somewhere else in that unit?
I actually can't speak to that. I'm not sure where that wall heater was, or whether it was removed as a result of the mold, or maybe it had been removed years ago and relocated. I actually don't know.
Okay, and did the contractors indicate that the mold that had, I guess, occurred in apartment number 6 was due to anything else?
So when you try to identify the source of mold, it's kind of a tricky exercise, because who knows, you kind of have to open up walls. It was the best guess of the contractors and our team that it was coming from a different location, and they sort of traced it back by looking at the wood and the evidence of any water, and that's how they traced it back to Mrs. Prejean's unit.
Okay, got it. And then were there any complaints on the apartment below her that there was leaking from the ceiling down?
Not that I'm aware of.
Okay, so it was just the apartment that was next to her, not the one below her?
Yes.
Okay, got it. And then looking at page 42, it's Exhibit 2, I believe it's the exhibit that you submitted. It says like dryer vent, and it's got that sort of black thing over that patio. Is that screen, is that see-through, or is that blacked out?
I think that's just a really bad picture. I'm pretty sure that's just a screen.
Like a transparent screen, or?
Yeah, it's been a while since I've been there personally. I can't say for sure, but.
And does apartment number 5, is it off of the main street? Is it off of Rosewood, or is it on the back side or on the side of the building?
If I remember right, this unit is on Kings. So the property is basically on the corner of Kings and Rosewood. So Rosewood is most of the property, but this property, I think, faces Kings, or this particular unit faces Kings.
Got it. Invisible from the street. Okay. Are there any more questions? All right, thank you. I will have the tenant return to the podium. You have 1 minute and 20 seconds left.
The washer and dryer, the washer on the balcony, the electrical was there when I moved in, and the dryer connection was put in for my dryer, and it's a common wall between the balcony and the kitchen. So that's where the connections, it's not like they're just randomly wandering through the apartment with the gas lines. And the mold is continuing to grow in the hallway between my apartment and the neighbors, and my neighbor as well still has a big orange spot, and it's getting bigger. Yeah, dryer connections in the common wall, mold continuing to grow. Oh, and I don't know if this is relevant, but I understand, it's possible that you won't be able to get my washer and dryer reconnected. And I will apply for a 504 accommodation, disability accommodation from the American Disabilities Association. And that type of thing doesn't say it can only be the same as every other apartment. It specifically says that an apartment that has a disability accommodation can be different from all the other apartments. because of...
So you're at time, but go ahead and finish your statement, and then we'll have to conclude it.
Okay.
But finish your sentence, please.
I'm sorry, what?
I was saying, go ahead and finish saying what you were saying.
Oh, okay. Well, that's it. I just, I'm sorry, I'm having a little difficulty breathing today. The fact that other apartments don't have a connection in the apartment doesn't mean that it can't have it. And it doesn't cost $12,000 to put in a washer and dryer connection. It may reasonably need to be updated, but they don't need to rip out the whole bathroom and put it in again or turn it into specifically only a laundry room.
Okay.
It can be the way it is.
Thank you. Are there additional questions for the tenant? Okay. All right, thank you. You can take a seat. We're going to discuss the case and deliberate and sort of make a decision, but you're free to sort of stick around while we do that.
I'm sorry?
Oh, no, I was saying
Question?
you can sit down. No, we don't have any questions. Thank you. Okay, if the commissioners are ready to deliberate, I will go ahead and close the public hearing on this item. And if there are any volunteers for who would like to kick us off, jump in.
I'd like to just say that this is a difficult one because I certainly see the need for a washer and dryer in unit for mobility issues, and I've heard the tenant on that, and I have sympathy for that and would like to call out, I'm not an attorney and I have not followed this legislation closely enough to speak much about it, but the new state law that allows tenants to move to the lower floors and the landlords to allow that if there's a mobility issue. So that is an option on the table, regardless of what this commission decides. So our role here is not to reweigh the evidence. So the hearing examiner makes a decision. And our role is essentially, as I understand it as a non-attorney, is to determine whether a reasonable person in the hearing examiner's shoes could have come to that decision. So I look at the estoppel certificate from 2015 that says there was a reference to a washer and dryer, but then I see the re-registration form in 2019 that says that there was not, and testimony from two people kind of saying it was from the landlord, it was not. And at that point in time, it's kind of a 50-50, and regardless of where I would come down on that, and I'm not sure that I would have come down to the same position as the hearing examiner, we don't get to make that decision here. We get to decide, would a reasonable person make that decision? And I believe, even if I disagree with it, that a reasonable person would. So for that reason, I'll be supporting staff's recommendation.
Thank you.
Okay, thank you, Chair. I'll try to be quick. So clearly, I'm sympathetic to the tenant and the fact that the tenant is losing the such an important service, which is washer and dryer in the unit, which is very significant service, especially in the rent control apartment in the city of West Hollywood. So there's no question about it, the impact that the tenant will have, the tenancy without the washer and dryer in the unit. And I have to say this also, considering that the washer and dryer were in the unit for such a long period of time, but over 2 decades, it's hard to believe that a landlord or landlords before, they had no idea that there was a washer and dryer in the unit. So there is no way somebody can convince me that the landlord or landlords did not have any knowledge of it. And when I look at the photographic evidence presented to this case, the extent to which the work was done to alter the area in order to put these appliances. Clearly, in my opinion, this type of work could have not been done without the landlord having a knowledge or even helping to do this. So that's my opinion. However, we heard tonight there was not a single evidence that would substantiate that proof, or that any evidence, any proof that any landlord had knowledge or permitted installation of this washer and dryer in the unit. And the tenant herself testified tonight that, to the fact that there was nothing, not a single document. Obviously, 25 years ago, there was no email, maybe, or text communication, that type of communication with the landlord. So these days, it would be easy. You text the landlord and he responds, there is a proof. But at the time, there was nothing in writing. There is no proof, as the Commissioner Abbas mentioned. Also, the re-registration form, specifically those boxes that mention in-unit washer, in-unit dryer, they're unchecked, and that is something that we cannot ignore. So, having said that, I have no choice but to support the staff's recommendation, because the record before us shows that the examiner didn't err in the findings in this case. So I'm prepared to support the recommendation from the staff. Thank you.
Commissioner Martz?
Yes, I will be brief on my comments because Commissioner Bass said it exactly how I would say it. And I don't think you need to ever preface again that you're not a lawyer, because you do great. So what I would like to clarify is, for the parties here, is we are very restricted on what we have the power to do. I call the hearing examiner a baby court, and we're a baby appeals court. And so our job is to look at what the hearing examiner decided and to decide, in layman's terms, if they did it right or wrong. And for us to overturn them is a pretty big step to get to. And what Commissioner Bass said, which I agree with, is the record that was created by the hearing examiner, there's substantial evidence before us to agree that they made the correct decision with the evidence they have. Like you said, had we been making that decision, it might have gone either way, because this is a very close case. I'm going to support the hearing examiner's decision and uphold it. What I would say to all the parties here is, you can refile and like you said, it's a long time ago, but if there was something more to convince us that this landlord had actually been involved in this process, whether it's a handyman that helped, if there's other things, even one or two scraps of paper might have swayed me here to go the other way. So that's what we were looking for in this case. Those are just not there because both of the parties kind of had equal weights of what they were saying, and to overturn, we would need one side to be heavier than the other. So those are my comments.
Commissioner Kerpes?
Sure. So I will agree with the hearing examiner's determination as well. But the reason I have no, other than just not liking how it's turning out, there's no reason, I don't have any conflicts with the facts here. I think there's no dispute that the landlord in the past knew and helped you put that in. There's no dispute there. But I agree with the hearing examiner in that there was no service lost. This was a situation where the tenant paid for paid for the items being installed. They paid for all the maintenance throughout the years, even put a deposit down to say, when I leave, this is coming with me, or this will pay for your expenses in removing the adapters. So other than the fact that being there and being allowed to be used, I don't see where, and I don't think that the allowance from what I've heard tonight and from what I've read here, there was no denial of the allowance of using properly fitting devices. This is not a situation where, the city said you can't use that parking spot anymore, it's not safe to park there, and the landlord took it away.
Commissioner, can you speak into your mic?
Oh, sorry.
Thank you.
Then the landlord took it away. This is a situation where the items that the tenant owns are not safe to use. But if there were a way for safer items to be used in that same purpose and safely, the landlord does not seem to be objecting to that. And I know that's a huge expense for the tenant, but it sounds like they're in a situation where the landlord is willing to work with them on that. So that's my reason, but I do agree with most of the things that were said.
Thank you. Vice Chair Moore?
This is a tough one for me too. I really was trying to find substantial evidence to prove that this was a housing service that was removed, and I was not able to find that. One, the unit's re-registration form did not select in-unit washer dryer as part of a housing service, and I understand that you did sign that dated February 19, 2022. There's also no evidence to show that the installation was paid for by previous landlords. I'm very sympathetic to having this being taken away from you. And I wish that there was something that we could do, but as commissioners, we don't have that power. So I will also agree with staff's recommendation to uphold the hearing examiner's decision.
Commissioner Rory?
Chair Wright, could I go after you just because you asked so many good questions? I want to hear what your thoughts are.
Okay, sure thing. So I think where I started with this was looking at whether it was actually a housing service. And so I turned to the Municipal Code 17.08.010, subsection 13, subsection 1, that defines what housing services are for the year that she began her tenancy there. And so just in relevant part, it just says services provided by the landlord, and that includes ordinary repairs, replacements, and maintenance, as well as laundry facilities. And so the services provided by, I think, is where I was curious, is sort of like, well, what does that mean? You know, is it enough if the landlord helped install it, or would there have to have been an additional action or additional actions by the landlord in order to turn this tenant-installed washer and dryer into a housing service? And so I turned then to the Municipal Code 17.56.10, which is maintenance standards. And it sort of outlines what the landlords are responsible for. A3 is that units shall be maintained in accordance with all applicable building, housing, and health codes. And the pertinent part, B, all appliances provided by the landlord shall be maintained by the landlord so they are in good working order. And so read in tandem, those two provisions in the code are essentially, you know, I interpret them to mean that if the landlord had provided those, the washers and dryers, then they'd be responsible for maintaining those. But because the tenant provided it and the landlord didn't provide any additional maintenance to those, that there was really no way to convert that into a housing service. And you know, we got testimony from the tenant that said that she paid for all the repairs, she paid for all the upkeep, and so in my mind that shows there was no intent or even unintentionally where that somehow became a housing service because the landlord maintained those two appliances. And so I think I'm certainly, as my fellow commissioners have said, not satisfied with the outcome because, you know, the tenant did mention, you know, that it's not easy to go up and down the stairs with laundry, et cetera. And so I'm hoping that, you know, if you haven't already, to the tenant, reach out to rent stabilization or permitting, because it's been there for 20 years. I wonder if you're somehow grandfathered in, if they're, just sort of seeing what the other options are. And so, but even with that, because I can't define it as a housing service, I will uphold the hearing officer's decision. Commissioner Rory, it's on you.
Well, I just love that we come at this with all these different perspectives. I think I'm definitely going to support the resolution on the table. I wanted to share with my fellow commissioners my thinking a little bit on this, just maybe even, and for future references as well. To me, obviously, I feel bad that a tenant doesn't have a washer and dryer anymore, but I was so struck by the code issues right away that I was immediately sympathetic to the landlord, saying there's other people in the building that they have to protect and take care of. You have gas lines running through walls, you have electrical running through walls, you have exhaust. And I guess maybe I come at kind of from like a facility standpoint, just from taking care of my own home and managing other buildings. To me, this was like, oh my gosh, you can't have a washer, dryer, and a shower. It just, you can't have that. But what it sparked to me, and something that we've encountered in some of our other hearings as well, is this issue that when you have a code violation, it can still be a loss of a housing service. And that still, to me, is really hard to accept. I just want to be honest about that. Almost to the point where I would entertain future discussions about, I don't know, as a policy matter, whether this body could make any recommendations to council about this tension that I see. And we've seen it in a couple cases where there's a clear code violation, and yet we're still debating whether there should be a rent reduction or not. And I get legally how right now the way it stands, even if there's like an egregious clear code violation, it could be a loss of a housing service, and we have to still consider that matter. But I really struggle with that one initially. And I appreciate the landlord's just approach to all of this and what was said tonight. This was clearly something he wants to work on, but there's a code issue, there's a cost issue. And for me, I was never really in doubt how this was gonna, for me, how I was gonna vote. But I did want to mention to everyone on this body this code issue and how that doesn't seem to matter for the loss of a housing service. But to me, if I'm the landlord and I'm thinking of all the other people in the building, that's a tough one to say, there still has to be a rent reduction, even if there's something that's just so, on its face, incorrectly done and a danger to other people that now we have to even go down this path of a rent reduction. And so that's how far I was on the other side of thinking this is just cut and dry. But I wanted to share my thinking on that. And I saw the through line to other appeals that we've had and on the same the same tension.
I think I appreciate you sharing that, and also the violation part. I think I watched at least 2 of our prior meetings trying to find the one where that came up, and I didn't, so I'm happy you said it because I thought I was going crazy for a minute there. So thanks for that. I think the other question that I had, and maybe it doesn't sort of matter, but you mentioned it, was that we're sort of saying that it's a code violation. It's a code violation. Is it? I mean, I haven't seen proof that it is. I mean, I can look at it and say, I don't know that they would install it that way today, but I don't know that looking at it that I can infer that it is. And there was nothing in the record that said that it was. So I was just curious if sort of, is that your just background in knowing like the code that you know that it is, or like what is that?
I'm not a code inspector, but I'm speaking as almost like in legal terms, I think it's almost like res ipsa. Like I look at that and certainly from a design and a product design standpoint and an exhaust design standpoint and an electrical design standpoint and a gas design standpoint in a shower. Gas lines don't run through shower walls typically. So it's just total lay opinion, but it's almost to the point of like res ipsa. And the other case that we had this issue that I remember, it was an outdoor patio. I want to call it a bookcase, but it was a plant stand that was blocking an exit path for like a fire emergency. And there was the loss of that plant stand, and we were like, no, that's a housing service. And I really struggled with that one too. I was like, but people have to leave if there's a fire, and so what's the landlord supposed to do? But that's what I remember.
Great, awesome. And just for sake of the record, the tenant testified that the gas line ran from the kitchen through a wall to the patio, not through the shower, but just for the record for that. So it looks like we might be ready to make a decision. Fantastic. Would anyone like to make a motion in regards to the appeal?
I will do so. I am going to make a motion to adopt resolution RSC number 24-644, a resolution of the Rent and Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D-4794.
Is there a second?
Second.
There's a motion and a second. Is there any further discussion on this item? Okay, seeing no yeses on that, Madam Secretary, can we have a roll call, please?
Yes, Commissioner Bass,
Aye.
Commissioner Kerpes,
Aye.
Commissioner Martz,
Aye.
Commissioner Rory,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Moore,
Aye.
Chair Wright.
Aye. Motion passes. If the parties have further questions, you can reach the Rent Stabilization Division at 323-848-6450. You can also email at rsd@weho.org. Excuse me. The next item on the agenda is new business, which there are none. Item number 10 are items from staff. Oh my God, Jesus Christ.
I'm sorry, I didn't hear what was said.
Yeah.
Yes.
No, I was totally convinced. I was like, yeah, I said it was July, so I probably didn't. All right. Are there any items from staff?
I'm trying to recuperate from that. Chair Wright. Yes, I have a couple of announcements. The City Clerk's Office, City Attorney, and Communications Department are conducting a mandatory training for appointed officials on February 29th at 6 p.m. in council chambers. The training will focus on California Public Records Act and the responsibility as appointed officials under the act. Social media as it relates to your role as an appointed official under the Brown Act will also be discussed, as well as the city's media policy and who is designated to speak on behalf of the city. If you haven't, let the city clerk know. If you can attend, please do so as soon as possible. Similar to the Code of Conduct training, the city clerk's office will provide a way for you to make up the training if you're not able to attend. And the other announcement is City of West Hollywood is inviting community members to a community open house to kick off the development of West Hollywood's next citywide strategic plan, WehoTV, and on Saturday, March 2nd, 2024, from 11 a.m. to 2 p.m. at Kings Road Park. This free event will include a brief program, food, and live entertainment. Stop by any point during the event to learn more about the project, to provide feedback, and to connect with fellow community members. Visit engage.weho.org/WeHo Strategic Plan to learn about the latest WehoTV updates and sign up for project-specific announcements. And also, if you weren't able to attend the last study session that we had, I truly, truly recommend that you watch the recorded session. It was very informative. It was very fun. I believe we also included the video, right? That was shown, which was pretty entertaining. Those of you that weren't here, we missed you very much because you guys are the life of the party. So, and that's it with my announcements.
I had a question about the mandatory training next week. Would there be food, and can we do it via Zoom?
I will get back to
Separate
you
questions?
about that.
At the same time.
Yes, I will definitely email you about that. I'm not really sure what's going to be provided, but.
Okay.
So if there's food, you won't be on Zoom?
I was hoping the food would be delivered to my home while I watched it on Zoom.
I'd like to know why the city is choosing our extra day of the year to have us all come to City Hall and do this, but I won't be able to make it, but she already knows that.
Okay.
All right. Any additional questions for staff? All right. Item number 12 are items from commissioners. Sorry, item number 11 is public comment. Are there any speakers for public comment?
No public speakers tonight.
Alrighty, so no one came, okay. Item number 12 are items from commissioners. Commissioner Topchin?
Yes, Chair. Since the resolution was already passed, so I just want to take this time and make some comments about the discussion that Commissioner Rory brought up, and Commissioner Wright, you as well, regarding the housing services and the code violations. This is a topic that I was very enthusiastic about many years ago, and I advocated to adopt regulation that would be similar to what the city of Los Angeles currently has, which is basically pretty much says that any housing service that was created, it pretty much it says rent reduction will be applicable for those services that were created in violation of the law. So, and in their cases, investigations, instances such as this one, washer and dryer was created in violation of the law, or there was a patio that was created in violation of the law, or let's say there was an illegal parking structure or garage that had to be demolished but was created in the violation of the law, and the tenants in those type of scenarios, they suffered a rent reduction, the department would pursue a rent decrease for those cases. Even when the inspectors of the same department would cite those violations. So I think that, you know, this discussion I really enjoyed, listening to your comments, and as I said, I advocated years ago, but it was different timing, different commissioners, different department, different council. So maybe this time around would be a good idea to kind of say, I see the support of some of the commissioners, at least during this discussion. So maybe bring this up again and have a discussion at the commission, and maybe we can make a recommendation to adopt similar what the city of Los Angeles has. Because I believe that, you know, if LA has something like that, why the city of West Hollywood cannot? So that would conclude my comment. Thank you.
Chair, just real quick to just maybe cut off anything, I just want to say, to the extent that the commission wants to discuss this as a policy matter for, you know, even a potential recommendation to council, whether it's through a regulation amendment or code amendment, we can have that scheduled for a future meeting. But I just want to avoid a like down the line discussion about this, just because it's not agendized under the Brown Act. And so I would also think that members of the public would probably be interested to hear that discussion. So I know it's a very interesting topic, but I just wanted to get ahead of that. Thank you.
Would it be helpful if we passed a motion to have this added to a future agenda? Or does it suffice that we've discussed it and sort of given direction in that way?
I think as long as the commission can just give direction to bring that back as a future item, and what we can do is we can have a discussion item on it, seeking direction from the commission, and if the commission as a body wanted to pursue some sort of recommendation to council, whether again it is a regulation or amendment, then it's going to be like a multi-step process. But as this commission has had before, we've brought code amendments to you to review, comment on, and recommend to council. So that is an option.
Okay, and I would add to that, if we could have I guess the LA, it sounds like LA has a similar policy, and maybe look at what Santa Monica is doing. So as part of that item, we can sort of review what's there as part of our discussion. Okay, thank you. Commissioner Bass?
2 questions. First one is in regard to this that we're discussing now, the code violations. If we ask for something like that, how does it fit within staff's work plan? Because I understand that only council and the city administrator, or council through the city administrator, can really alter staff's work plans. So I worry about asking for something that then staff doesn't have the authority to actually bring back to us.
I'll be talking to the director and seeing if this would be something that could be added to our work plan. I just need clarification, because what I understood from Commissioner Rory was that he was not in favor of allowing a reduction on the rent for a serious code violation. That's what I understood from Commissioner Rory. Where from Commissioner Topshin, he was saying the complete opposite. He was saying that if it is a code violation, there should be a rent reduction in place. So I just want clarification on what you guys want to bring forward. To support the rent reduction for the code violation, or to indicate that if it is a code violation, the tenant should not be entitled to the rent reduction.
Since I'm already have my mic on, I will suggest, without offering an opinion one way or the other, based on legal counsel's advice, we not continue that maybe an overarching discussion of what other cities do and what staff's position is on something like this might be the way to go. And then we have 7 very opinionated people here who will, at that time, and when it's properly noticed, let you know beyond my 2 colleagues where they stand.
Duly noted.
Does that help? That's
yes,
where
it
I'm
does.
at. So the second one is on the rent stabilization news. I really appreciated it, but where it starts out with the reduction of 5%, or the 5% interest payments due in January. Is it late this year, or is there some reason we're getting this in March, or almost March?
Yes, it is late. Normally, we either send it end of December, early January, so landlords are aware that they have until the 31st to pay that interest rate. But we lost a really important person in our staff, so it's kind of delayed a little bit of things, and we apologize for that.
And I appreciate that. I was reading it and wondering, why are we talking about this in
Yes.
basically almost March? So
Good catch.
thank you.
Yeah, in part of that presentation that comes back to us regarding that, if we could, I think it's very much connected, but also if we can include in that presentation, not only the history of where we are today on in terms of the services versus code violations, but also kind of a focus that a reminder that rent reductions are not, or rent reductions for services are not penalties, that they are a value issue, not punitive, I think is what I'm trying to think saying. And then also in that conversation about making sure that the perspective of the landlord, or the perspective of the tenant who makes an agreement when they sign a lease somewhere, of what their understanding of what their future holds and what they're paying, because I think that that's sometimes lost in the battles that we see here. We forget what 10 years ago they signed up to pay rent for. Thank you. Oh, and I just really appreciate both the tenant and the landlord this evening, the courtesy that you showed each other, and this is a very difficult issue, I can imagine. So I appreciate the courtesy you've shown to each other and to us tonight. Thank you.
I just wanted to remind folks there are some really great events still going on this month in the city. On Saturday, the 24th, from 2 to 3:30 here in Chambers, there's the Lesbian Speaker Series, celebrating 35 years of Black lesbian organizing in LA. And then also on the 26th, from 6 to 7, the Coalition for Economic Survival, Coalition for Economic Survival with the City of West Hollywood's having a Know Your Rights forum for tenants. It's via Zoom, and the link is on the city's calendar. So, and that again, that's the 26th, 6 to 7 for tenants to know your rights. I believe that will do it for this evening. The next meeting of the Rent Stabilization Commission will be...
I have one comment.
Oh my God.
Yeah, sorry.
All right, go. Hit it. Just jump in.
Go ahead.
I wanted to echo Commissioner Kirby's comments. Tonight's both the landlord and the tenant were probably the most civil that I've seen since I've been up here, and I just wanted to say that to you both. Thank you both for your professionalism and what you brought to the table. So it's really refreshing. I wanted to say that. And on the item that Commissioner Bass kind of steered us to come back on, I wanted to be clear, I hadn't made up my mind one way or the other. I just struggle with this issue, and it sounds like other people are interested in talking about it more, so I'm glad we're gonna possibly talk about it more in the future. And I apologize for missing the study session, but I was out of town on work, and I did view the video part of it, and I'm gonna try to get through the rest of it, and I'm sorry I wasn't there, but it was for a good reason, so I wanted that to know. And I will be at the study session at the end of the mandatory training at the end of the month. Zoom or dinner or none?
All right, last but not least. This is going to be the second to last of my meetings. I will be resigning next, not by choice, but because I'm joining Best & Krieger, the law firm for West Hollywood, and that would be a conflict. So I will be working on the other side of the aisle on city matters. But yeah, so next meeting will be my last one.
It's a pretty good reason. At least you're still giving some service to the city, except making a little more than $70 a meeting now. So fantastic. Alrighty, we are adjourning until our next meeting on March 14th, 2024 at 7 p.m. Same place, same time. Have a great evening.